So, hello and welcome everyone for the next season of Rotaract Talks. And today we would be having Sudhanva Bedekar to speak on the topic Demystifying Kesavananda Bharati versus State of Kerala. So, this topic was eventually, first of all, I would like to thank Sudhanva for actually agreeing to my kind request to speak on this topic at such a short notice. So I remember I spoke to Sudhanva the day before yesterday, and we were having this conversation that Sudhanva, I would want you to speak on this topic. And Sudhanva, at this, at the moment, said that it won't be an issue for me. I would just love to do it. So first of all, thank you so much, Sudhanva, for agreeing to our request. And we are really grateful that you have acceded to our request, and we hope that it would be a pleasure listening from you. I've heard you. I've heard from you at moot court competitions, and I have always been, a big fan of yours because the way you speak and the charisma that you have when you speak, it is just something which is awe-inspiring for me. So before Sudhanva starts discussing the topic today, I would just want to make things a bit easier for Sudhanva by just giving a brief about why this topic is important and why I think we should be discussing about Kesavananda Bharati altogether. So Kesavananda Bharati becomes important because in this league we see a lot of social activism these days which is happening. People talk about that, I have this particular right, I have that particular right, you cannot curtail my right. So from where does this where does this concept of curtailment or non-curtailment of rights actually came in. So it was basically the Supreme Court giving his judgment in Kesavananda Bharati, saying that the Parliament can abrogate any for that matter the Parliament can amend any part of the constitution, including part 3 of the constitution. But what the Parliament can't do or can't amend is the basic structure. So the basic structure doctrine basically flowed from the landmark judgment of Kesavananda Bharati. And there's a series of discussions, I'm sure, which Sudhanva would be taking up. Now, there's one important aspect, that I would really like to mention about before I ask Sudhanva to take up the stage. And that important aspect, because since this is going to be a learning process, I am very much fascinated by the lawyer who argued this particular matter, which happens to be Mr. Nani Palkiwala, and he's just an inspiration for all of us. And I would just like to share that Nani argued this matter as well, apart from several other matters, like we had a privy purses matter, and then I just can tell you so many. So Nani argued most of the matters concerning the fundamental rights violation, and in most of the matters he appeared by filing an impediment application. So that was back then, when and today the filings in Supreme Court happen when you want to argue with the matter before the Supreme Court. You just have to submit your written pleadings, and then the matter goes on. So back then the rule was that you used to file an impediment application, and then you were allowed to argue the matter. So Nani argued this matter, and it was such a it was the nation's goodwill, a good luck for the nation that Nani happened to argue this matter, because the earlier matter, as in the decision which was passed by the Supreme Court in the Sajjan Singh case, the Supreme Court, by the ratio of 3:2, said that the Parliament has the rights to amend any part of the Constitution for that matter. And this was generally the ratio of Sajjan Singh, wherein the court said that by 3:2 ratio, that's a very narrow ratio. And eventually landing up to Kesavananda Bharati by 7:6, wherein the Supreme Court said that no, you can't take away the basic structure of of the Constitution that is there, and you can't go on to amend the basic structure. So on this note, I invite Sudhanva to please proceed with the discussion, and I hope that you all would enjoy the discussion. Over to you, Sudhanva.
Thank you very much, Karan. Today morning, we all woke up to the news of the passing of His Holiness Shri Kesavananda Bharati. And I don't think there is a single law student in the country who has never heard this name, Kesavananda Bharati. Now we have encountered a very strange happenstance, since today's topic revolves around Kesavananda Bharati. Now, at the outset, I am going to take the liberty to tweak the topic a bit. Instead of demystifying Kesavananda Bharati's case, I would like to revisit the entire Kesavananda Bharati jurisprudence. So therefore, hence I say that today's topic is revolving around Kesavananda Bharati. And we are not strictly going to demystify Kesavananda Bharati in the sense that I am not going to discuss the intricate details of that particular case, of the case of Kesavananda Bharati. This is not a case review, this is not a case comment. This is just an attempt to take an overview of the development of the entire jurisprudence of the basic structure, right from 1952, how the jurisprudence came to be developed, right up to 2015-16 when the NJAC case was decided by the Honorable Supreme Court. And I will also try to identify some problem areas with the basic structure as it stands today. Now, we all know that in our constitutional scheme, we follow to a certain extent, of course, the principle of separation of powers. Now, what it means is that we have a legislature, an executive, and a judiciary. A legislature which makes laws, a judiciary which interprets those laws, and an executive which is tasked with the implementation of those laws. Of course, the principle of separation of powers is not strict in India as it is in the USA. But nevertheless, there is a great degree of separation which is to be respected. Now, the function of the judiciary, if we go to see, the traditional function of the judiciary is settlement of disputes, deciding lists between parties. In the Indian context, and for that matter, in all the modern democracies in the world today, the more important function of the higher judiciary, the High Court and the Supreme Court in India and the constitutional courts elsewhere in the other countries, is the function of judicial review. What is this judicial review? Judicial review basically means that any law which is made by the legislature can be challenged in a court of law, and the court of law can decide the validity of that particular law on the anvil of the constitution, on the anvil of the fundamental rights and other constitutional provisions, legislative competence, and so on and so forth. So in our constitution as well, the High Court and the Supreme Court has this power of judicial review. Now, where from this power of judicial review comes? It comes from Article 13 of the Constitution. Article 13 clearly stipulates that if there is any law which abridges or abrogates fundamental rights, that is rights contained in Part 3 of the Constitution, then that law to such extent will be void. Now it is for the courts, that is the High Court and the Supreme Court, to pronounce on the validity of such a law. Now what is law is also a very critical question, which is also answered in Article 13 itself. Article 13 defines law in such a sense that first and foremost it is an inclusive definition. So it is not restricted by the enumerations, the strict enumerations which are contained there. It includes ordinances, orders, bylaws, rules, regulations, notifications, even customs for that matter, and obviously legislations. The question which then arises is whether a constitutional amendment is also law within the meaning of Article 13. Because if we are to say that a constitutional amendment is a law within the meaning of Article 13, then the natural consequence that follows is that the particular law, if it abridges or abrogates the fundamental rights, will be struck down, will have to go. So therefore, if a constitutional amendment violates the fundamental rights or even touches upon the fundamental rights, then such a constitutional amendment can be struck down by the court of law due to such an interpretation of Article 13. Now this was the question which took 23 years to decide after the enactment of the Constitution. Question is whether a constitutional amendment is a law within the meaning of Article 13 or not. Now you all may be aware, since most of us are law students over here, that when in 1950 the Constitution was enacted, immediately elections were not held. In 1952 the first Lok Sabha was constituted. Until such time, the Constituent Assembly itself continued as the provisional parliament. And the war cry of the Jawaharlal Nehru government at that point in time was agrarian reform. There was a great deal of poverty in the country. There was exploitation by the landlords. So therefore, agrarian reform was the war cry of the government. Naturally, in the constitution where right to property has been regarded as a fundamental right, any agrarian reform measure is going to come into conflict with this right to property. Because agrarian reform or land reform is seen as a measure which is pro-tiller of the land and somewhat anti-landlords. So therefore, this conflict was always going to be there. Several states in the 1950, 51, 52 time brought in land reform legislations, and all those land reform legislations were challenged in the various high courts. 3 high courts decided these land reform legislation, the challenges to land reform legislation on the anvil of the right to property and several other grounds as well. It was the Madhya Pradesh High Court, Allahabad High Court, and the Patna High Court which was called upon to decide these issues. And the Patna High Court struck down the Bihar land reform legislation on the ground that it violates the right to property, which is a fundamental, which was back then a fundamental right under Article 19(1)(f). Obviously, the government was not going to take this sitting down. It was also stung by several other judgments of the Supreme Court. There was a reservation in Madras, which was struck down in the case of Champakam Dorai Rajan by the Madras High Court and then by the Supreme Court. Then there were two free speech judgments as well, Brij Bhushan and Romesh Thapar. There were some preventive detention judgments as well. Now, all this was seen as an interference by the courts in the affairs of the government. And therefore, the government and the provisional parliament got jittery and the first amendment of the constitution was tabled. This first amendment, amongst other things, introduced two very draconian provisions, Article 31A and Article 31B. Now, what this 31A and B basically did was that 31A laid down that if at all there is any agrarian reform law, land reform law, which is challenged in the court of law on the ground that fundamental rights are violated, the fundamental rights will go out of the window. The agrarian reform law will prevail. So 31A was kind of an immunity. 31B went a step further. What 31B said was that even if a particular legislation is struck down by a court of law on the ground that it violates fundamental rights, if it is put in the 9th schedule of the constitution, till then there were 8 schedules, the first amendment introduced this 9th schedule. If it was put in this 9th schedule, then automatically it survives and it crops back in. Now we all are aware of the story in Mahabharata where Karna was blessed with these Kavach Kundalas. So if there is any weapon which is used on him, those weapons will pay obeisances to his Kavach Kundala and go back. So similarly, this 9th schedule acts as a Kavach Kundal for all land reform laws and in fact even other legislations, because in this 9th schedule several laws which had nothing to do with land reform were also later included. Obviously this was going to be challenged in the Supreme Court and it got challenged in the case of Shankari Prasad Singh Dev. Now this Shankari Prasad judgment is in the year 1952 by a constitution bench of the Supreme Court. The constitutional validity of these two articles, 31A and 31B, was challenged in the Supreme Court in this particular case. And the first question obviously before the court was whether a constitutional amendment is a law. Because if this first amendment was held to be a law within the meaning of Article 13, then it could have been struck down very easily. But then the court was confronted with the theory of constituent power and also it was confronted with the language of Article 368. If we are to read Article 368, a literal interpretation of Article 368 will take us to the conclusion that there are absolutely no restrictions on the power of Parliament to amend the Constitution. And the theory of constituent power also says that there can be absolutely no limitations whatsoever on the constituent power. The constituent power is vested in the Parliament in our constitutional scheme. So therefore, having all these factors in mind, the court came to the conclusion that constitutional amendment is not a law within the meaning of Article 13 and therefore, sorry, we cannot help you. 31A and 31B will have to pass muster, will have to be held to be valid and therefore no relief was given to the petitioners. Then subsequently a period of 14 years and 16 amendments passed. And then there was this 17th amendment which populated the 9th schedule with 44 laws. Now these 44 laws also included some laws which had nothing to do with land reform. This 17th amendment came to be challenged before the Supreme Court. And it was in the Sajjan Singh case that the court considered again the issue as to whether constitutional amendment is law or not. Now mind you, the court in Sajjan Singh did not consider the validity of the 17th amendment. It first considered the question as to whether, since this was also a 5-judge bench and Shankari Prasad Singh Dev was also a 5-judge bench, the first question it considered was whether Shankari Prasad Singh Dev required a reconsideration. Because if it required a reconsideration, then a 7-judge bench could be constituted and then it could go into the validity of the 17th amendment as well. But the court held by a 3:2 majority that this constitutional amendment cannot be regarded as law, and there is nothing wrong with the Shankari Prasad Singh Dev judgment, and therefore the matter ended at that. Now, interestingly, Mr. Nani Palkhiwala was to argue this case, and Mr. D.M. Popat, if I am not mistaken, had requested Palkhiwala to come to the court and argue the matter, because he apprehended that Chief Justice Gajendra Gadkar would close the arguments in a day or two. But Palkhiwala was of the opinion that arguments would go on and on for a few days at least, and then he could come in someday and argue and convince the court to reconsider Shankari Prasad. But the apprehensions of Mr. Popat were found to be true, and suddenly one day Chief Justice Gajendra Gadkar closed the arguments and reserved the judgment. So Palkhiwala lost the opportunity to argue Sajjan Singh. And in fact, if he had argued Sajjan Singh, it would not have come to Kesavananda at all. That is also a likelihood. So in Sajjan Singh by a 3:2 majority, Shankari Prasad was found that it was correctly decided and no interference was required. There were two dissenting judges. And those dissenting judges were Justice Hidayatullah and Justice Mudolkar. Justice Hidayatullah compared Article 13 and 368 and ultimately said that the statute, the language of the statute, the language will have to yield to the principle. The principle supersedes the language. And therefore, probably a fresh look at the Shankari Prasad judgment is necessary. And it was Justice Mudolkar who for the first time said that given the fact that there are no restrictions expressly mentioned in Article 368, and by the very nature of this power, so wide that it is, there are some implied limitations which will have to be read into it, and that there is some basic feature, there is some basic structure of the constitution which should be kept away from ordinary majorities, and therefore he held that probably Shankari Prasad will have to be reconsidered. Obviously, he did not enumerate the items of the basic structure because the issue was solely whether Shankari Prasad Singh Dev needed a reconsideration or not. And he opined that yes, a reconsideration is necessary, but it was not to happen. 2-3 years down the line, now this was in 1965, Sajjan Singh was in 1965. 2-3 years down the line, Justice Subbarao became the Chief Justice of India. Justice Subbarao was known as a very rights-oriented judge. He was a pro-fundamental rights and anti-restrictions judge. He constituted a 11-judge bench directly and opened everything once again. And then, therefore, in IC Golaknath versus State of Punjab, this question as to whether a constitutional amendment is a law or not was opened up again. And this time in Golaknath, Palkhiwala indeed got an opportunity to address the court. And this time, by a 6-5 majority, the court overturned both Shankari Prasad and Sajjan Singh and came to the conclusion that constitutional amendment is a law. So therefore, the whole thing was overturned. It was turned, the jurisprudence was turned on its head. And the court said that constitutional amendment is a law. So therefore, constitutional amendments also cannot touch Part 3 of the Constitution. This was the jurisprudence in Golaknath. The natural question which arose in this case then was, what about the 17 amendments which have been passed and which have been held to be valid? Whether all those amendments will have to be struck down, or rather all those amendments which touch the fundamental rights will have to be struck down. The court then invoked the doctrine of prospective overruling to say that whatever has happened, but henceforth we will not permit any constitutional amendment to touch upon the fundamental rights. So therefore, Part 3, the fundamental rights, was kept away from Parliament completely. This particular judgment was wrong for one very prominent reason, according to me. It would have simply held that constitutional amendment is a law. It is not necessary that if a constitutional amendment takes away a fundamental right, automatically it can be struck down. Because even if a law takes away a fundamental right, or if a law imposes restrictions on a fundamental right, it is not that the law will be struck down immediately. The reasonability of the restriction will be tested. So similarly, the court would have held that yes, constitutional amendment is a law, but that does not mean that any constitutional amendment which touches upon the fundamental rights, or which probably makes some amendments to the fundamental rights, gives a restrictive interpretation to some fundamental right, automatically it will be struck down. That is not the consequence. But unfortunately, Golaknath did not say so. It turned the entire jurisprudence on its head. And obviously, the Parliament was not going to take this sitting down. Parliament immediately reacted. And the 24th and the 25th Amendment was passed. What this 24th Amendment did was that it said exactly the opposite of what was said in Golak. Article 13 was amended and the sub-article was added to Article 13. And it was clearly then laid down that constitutional amendment is not a law. It was clearly stipulated that nothing in Article 13 shall apply to a constitutional amendment. So out goes Golaknath. Then there was also an Article 31C which was added. This 31C, what it did was, it said that if there is any law which is made in pursuance, in furtherance of a directive principle of state policy, there were this one or two particular directive principles, it cannot be challenged in a court of law on the ground that it violates, or rather it cannot be struck down on the ground that it violates 14, 19 and 31. 31 was the right to property. And this was what the 24th amendment did. And this was again up for grabs. And then we come to Kesavananda Bharati versus State of Kerala. Several petitions were filed in the Supreme Court challenging the validity of the 24th, 25th and even the 29th amendment. And it was felt that probably the correctness of the Golaknath may also have to be decided. So at the outset, a 13-judge bench was constituted. And this 13-judge bench, which is case of Kesavananda Bharati versus State of Kerala, decided the validity of the 24th, 25th and 29th amendments. Now in this particular case, Chief Justice Sikri notes right at the beginning of the judgment that this 13-judge bench was constituted because probably Golaknath may have to be reconsidered. But we don't think that the question whether constitutional amendment is a law or not is relevant. The bigger question which is relevant in this particular case is as to what is the meaning of the word amend as it appears in Article 368. Whether there is a power to amend under Article 368, because prior to the 24th amendment, there was no power to amend. 368 talked about the procedure to amend. And Golaknath said that 368 does not confer the parliament with the power to amend. Power is to be found in 245, 246 and elsewhere. It is not to be found in 368. 368 merely lays down the procedure. But then the parliament amended 368 and included in the title of 368 the word power to amend. So the question naturally arose as to what is the meaning of the word amend. This question was put to Mr. Nani Palkhiwala. And in answering this question, Palkhiwala argued for a theory of basic structure or an implied limitation on the power to amend. The unique argument made by Palkhiwala in this particular case was that whenever the constitution is amended by following the procedure which has been laid down in 368, the constitution stands amended. It stands amended. So if there is any amendment which completely obliterates the fundamental rights or which takes away the basic structure or the basic feature of the constitution, if there is an amendment which takes away the character of the constitution does not remain the same after that amendment, then can it be said that the constitution stands amended? So therefore by this unique argument, he said that there has to be some restriction on the word, restrictive interpretation of the word amend. Another argument which he made was that, which was also highlighted by Justice Mudodkar in Sajjan Singh, that the very nature of this power to amend is such that you will have to read restrictions into it. It cannot be interpreted absolutely. Another argument which was reiterated in Minerva also by Palkhiwala was that this amendment, if it goes haywire, it would mean that the parliament, which is the product of the constitution, which is the creature of the constitution, will become the master of the constitution, and that we cannot permit. That balance will have to be maintained. And then obviously he gave some examples. He said that there may be some extreme amendments. What if there is an amendment by virtue of which the control of the government is given to the princely states, the princes of the princely states? It is perfectly possible under the present setup of Article 368, 2/3 majority, and it is done. Or what if the elections to parliament are postponed? If the tenure of the Lok Sabha is increased to n number of years, what do we do then? 368 may permit even such an amendment. So therefore, all these examples of extreme amendments he highlighted to show that there has to be some restrictive meaning to the word amend in Article 368. The natural question which was posed to Palkhiwala was as to why should we presume or assume that there will be some extreme amendment of such a nature? To which Palkhiwala answered that you have not encountered such an extreme amendment probably yet. So therefore you are asking this question. Whenever you will encounter such an extreme amendment, you will yourself devise some theory to strike down such an amendment. And these words of Palkhiwala in fact turned out to be prophetic, because by the 39th amendment, the Prime Minister and the Speaker were put above the law. And that 39th amendment was challenged in the Supreme Court in the case of Indira Gandhi versus Rajnaran, to which we will deal with it later. And in this particular case, 4 out of the 5 judges were the dissenting judges in Kesavananda. All of them used basic structure to strike down the 39th amendment, which was in fact the extreme amendment which Palkhiwala talked about in Kesavananda. So therefore, in this manner, Palkhiwala argued for a basic structure. He had with him an article of a German professor, Dieter Konrad. Dieter Konrad had with him the experiences of the working of the Weimar Constitution, the constitution of the Hitler era. Hitler also was elected to power according to the procedure which was given in the constitution, but then he completely obliterated the constitution by amending it and became the supreme leader. So therefore, keeping in mind those experiences, the German basic law, the German constitution which succeeded the Weimar Constitution, has in it an Article 79 which talks about an express limitation on the amending power. There are certain provisions of the constitution which cannot be amended. The German constitution has made an express provision in that regard. So Palkhiwala argued that we have not faced such an experience. So we will have to read an implied limitation. We will have to read the basic structure into the constitution. This is how the basic structure was ultimately brought about, it came about. And mind you, there was not a single judgment of any court which had ever struck down a constitutional amendment. Kesavananda Bharati was the first time. In fact, even Kesavananda did not really strike down anything. Only one small part of 31C was struck down. But the jurisprudence that constitutional amendments can also be struck down and there is something which supersedes the constituent power was first time laid down in Kesavananda by a 7:6 razor thin majority. And the court held that there is a basic structure of the constitution which cannot be amended. What all is enumerated, what all are the features which fall within these basic features or basic structure? The court held it has left it to the subsequent courts to decide. Obviously, there are enumerations of what all falls within the basic structure, but there cannot be a strict list of elements of the basic structure, and the meanings of those elements can also be not be strictly defined. So therefore, the ratio of Kesavananda is not as to what all are the elements of the basic structure. The ratio of Kesavananda is that there is a basic structure of the constitution which cannot be taken away by majorities, and that no creature of the constitution can be allowed to become the master of the constitution. That is what the ratio of Kesavananda is. The interesting fact again arises that out of those 13 judges, only 9 of them signed the final judgment of the court. So the question arises as to whether really it can be considered to be a judgment of the court. But nevertheless, it has been accepted and settled in our jurisprudence. So I don't think there is any room to raise that question anymore. But I think this was also some valid question which academicians can ponder upon. Obviously, it is going to be meaningless, but it can be pondered upon. After Kesavananda, there was the 39th amendment, which was the extreme amendment which we just talked about. As you all may be aware, Indira Gandhi's election to the parliament was set aside by a learned single judge of the Allahabad High Court. Appeal was brought to the Supreme Court, and the Supreme Court refused to stay the judgment of the Allahabad High Court, and her election was set aside. So then there was the emergency and all the consequences followed, and there was also this 39th amendment. What this 39th amendment basically did was that it said that if any High Court strikes down or sets aside the election of the Prime Minister or the Speaker, the appeal which will be decided by the Supreme Court will be decided on the basis of a law which is yet to be made. It will not be decided as per the provisions of the Representation of People's Act. It will be decided by a law which is yet to be made. So therefore, what you tell the Supreme Court is that without more, once the appeal against the order of the High Court is filed, you are bound to allow the appeal because the law is not framed and the constitutional amendment is clear. And then obviously this was challenged before the Supreme Court. And in the case of Indira Gandhi versus Rajnaran, the court struck down this 39th constitutional amendment. And interestingly, out of those 5 judges, 4 of them were dissenting judges in Kesavananda. And each of them used a different element of the basic structure to strike down the 39th amendment. For example, Chief Justice Ray, who had in fact superseded 3 senior judges after Kesavananda and become Chief Justice of India, he was rewarded for dissenting in the Kesavananda judgment, probably. Chief Justice Ray said that the principle of rule of law gets affected, and therefore this amendment cannot be allowed to pass muster. Justice Matthew said that democracy is a part of the basic structure and democracy is rendered meaningless. Justice Khanna, who was really the pivot judge in Kesavananda, said that free and fair elections are violated. Then Justice Chandrachud said that what about the principle of equality? These two individuals are placed above the rest and above the law. So therefore the principle of equality, which is a part of the basic structure, is affected and obliterated. And therefore this 39th amendment was struck down by the Supreme Court in the case of Indira Gandhi versus Raj Narak. After this, we came to the 42nd amendment. The 42nd amendment, in fact, is called the mini constitution. There were several amendments which were made, and the most important amendments which were directly hitting at Kesavananda were the amendments to Article 368. Article 368, sub-articles 4 and 5 were added. 368(4) said that no court can judicially review any constitutional amendment. And the interesting fact over here is that if a constitutional amendment is made in accordance with the procedure as per 368, or even if it is purported to be made as per the procedure laid down in 368, you cannot judicially review it. So therefore what it means is that even if the procedure laid down in 368 is not followed, but if simply an amendment is called a constitutional amendment, if it is purported to be a constitutional amendment, it cannot be called in question in a court of law. So it violates both the procedural due process as also the substantive due process and directly hits at the basic structure of the constitution. 368(5), as a matter of ample safeguard, reiterated that there shall be absolutely no limitation on the power of parliament to amend the constitution, that is the constituent power. There shall be no limitation on the constituent power. Then 31C, a new 31C was brought in. This new 31C said that if there is any law which is made in furtherance of any directive principle of state policy, it cannot be called in question in any court of law on the ground that it violates 14, 19, 31, etc. And then this was challenged in the case of Minerva Mills. And the court unanimously, using basic structure, struck down 368(4) and 368(5). Minerva Mills was also argued by Mr. Palkhiwala. Now, after this, this position of basic structure was fairly settled. Then the parliament did not confront the judiciary yet again with this particular basic structure problem, or rather it did not amend 368 or 13 further. This position was allowed to settle. And then there were several judgments which have used basic structure, which have interpreted basic structure. We are aware of the case of S.R. Bommai, where the court held that secularism is a part of the basic structure of the constitution. Then there is the 7-judge bench judgment of L. Chandrakumar, where the court frowned upon the tribunalization of justice. Then there are the judges' cases, the first judge's case, second judge's case, then the NJAC case as well. We have the case of I.R. Coelho, wherein the first amendment was up for grabs yet again. And all these judgments have expanded the contours of basic structure. Now, such expansion of the contours of basic structure has also led to some problems. So basic structure, which was evolved in Kesavananda as a means to curb some particular evil, has the tendency to itself get converted into an evil. So the medicine gets worse than the disease. The expansive meaning of basic structure has led us to this. Now I will also come to some problems with this basic structure. The first problem is that Kesavananda has done away with Golaknath. It has in a way done away with Golaknath. What Golaknath held was that Parliament, by amending the constitution, cannot touch the fundamental rights. What Kesavananda held was that there is a basic structure which cannot be touched. It is possible to touch the fundamental rights, but if it is a violation of the basic structure, then it is not possible. So therefore, there was some kind of a permission to amend the fundamental rights chapter. But now, the interpretation of the basic structure by the subsequent benches of the Supreme Court and the development of the jurisprudence has led us to the conclusion that almost the entire part 3 of the constitution is now part of the basic structure. So if there is any constitutional amendment which violates the fundamental rights, then it will be struck down not on the ground that it is law within the meaning of Article 13, but on the ground that it violates the basic structure. So almost all the important fundamental rights, at least, are now part of the basic structure of the Constitution and can be challenged before the court of law. So to this extent, Golaknath comes back. The problem further is that if Golaknath was allowed to survive, the Constitutional Court would have tested the constitutional validity of constitutional amendments only on the grounds of rights violations. So the challenges would be restricted to the fundamental rights. Now with Kesavananda, the challenge to constitutional amendments is not restricted only to the rights, it is also restricted to the structure of the Constitution. Now, for example, in one particular case, the court has held that parliamentary form of government is also the basic structure. Now, I really doubt whether it is correct to say that parliamentary form of government is also the basic structure. But this is what Kesavananda has led to subsequently. The wide interpretation of Kesavananda has now allowed the Supreme Court to consider both rights-based review and structure-based review of constitutional amendments. And there is a great deal of subjective satisfaction of the court which is now involved, because the contours of the basic structure are not capable of a precise definition. This is what is the second problem. This brings us to the second problem with the basic structure. The second problem with the basic structure is that these elements of the basic structure, firstly, are not definite. They are not restricted. There is no clear enumeration. They can go on expanding the contours of the basic structure. And that these particular contours of the basic structure cannot even be defined in a particular precise manner. The typical example that I always give is the case of NJSC, where the court has interpreted what is the meaning of independence of judiciary. Now, in the NJSC case, the 99th Constitutional Amendment and the NJSC Act were challenged before the Supreme Court, and the case was decided by a 5-judge bench in the year 2015. I think it was 2016, if I am not mistaken. Now, in this particular case, the NJSC system, what is the NJSC system basically? The National Judicial Appointment Commission was to be a commission of 6 persons, out of whom 3 would have been the 3 senior-most judges of the Supreme Court, Chief Justice and the 2 senior-most judges. The 4th person would be the law minister, and there will be 2 other eminent persons. These 2 eminent persons will be selected by a panel which consists of the Prime Minister, the leader of the largest opposition party in the Lok Sabha, and the Chief Justice of India. So these 6 people will make recommendations for appointments of the judges to the Supreme Court and the High Court. This was challenged before the Supreme Court on the ground that it violates the independence of judiciary, which is a basic structure of the Constitution. Now the question arises as to what is the meaning really of independence of judiciary. There are very few countries in the world where judges appoint judges. India is one of them. And there are several problems with the collegium system, which the Supreme Court itself has accepted that there are problems. And therefore this NJSC system was devised as a means to curb those problems or to mend the errors which are prevalent. And it is not that this NJSC system had excluded the judiciary completely. From those 6 individuals, 3 were going to be judges. 1 was going to be the law minister and 2 other eminent persons. So it is not that the participation of judges was completely excluded. But unfortunately, the court saw the participation of the law minister, the participation of the executive, as an interference with the independence of the judiciary. Now, in the United States, if we see, judiciary has no role to play whatsoever. It is the president who appoints judges of the Supreme Court in his discretion. So he can appoint anybody as a judge of the Supreme Court. And there are several examples where presidents have appointed members of the executive as well to the Supreme Court. In fact, members of the executive have also been appointed as chief justices directly. Chief Justice John Marshall, who is legendary Chief Justice of the United States, is a prime example of this. He was Secretary of the State and he was directly appointed the Chief Justice of the US Supreme Court. So independence of judiciary is not ensured by who is appointing. It is ensured by fixation of, it is ensured by unlimited tenure. In US, the tenure of the Supreme Court judges is not restricted to a particular age. They remain as judges till they are alive or till they resign. So this in fact ensures independence. The appointment does not ensure independence. This is also a legitimate argument regarding the contour of independence of judiciary. Obviously, there is a ground for disagreeing on this meaning of independence of judiciary as I have stated it to be. So someone may argue that in fact independence of judiciary is impaired by the existence of the law minister in this NJSC, and therefore NJSC will have to go. But the point that I am trying to make is that there is a there is a room for their reasonable disagreement regarding the meaning or regarding the contour of this particular element of the basic structure. And if there is a reasonable disagreement, then I think the legislature's autonomy, or rather the constituent power, needs to be respected. And therefore, this problem is very much prevalent. And if we are to read the dissenting judgment of Justice Chelameshwar in the NJSC case, he has pointed out at this very problem, and he gives examples also. He says that if, for example, the age of voting is increased from 18 to say 25, will that amendment then be called in question and struck down on the anvil of basic structure? Will it violate democracy? This is a question which will have to be decided on the basis of subjective satisfactions. Each person will understand this particular element of the basic structure in a different manner. And these problems are always going to be there because these elements of the basic structure cannot be defined properly. So a corrective step, according to me, is that whenever a constitutional amendment is challenged before the Honorable Supreme Court, the court should devise something which is something like a legitimate disagreement test or a reasonable disagreement test, which will act as an aid to the basic structure test. So the court should see whether there can be a reasonable disagreement regarding the contours of the particular element of the basic structure which is called in question in the court of law. And if there is a reasonable disagreement, then that reasonable disagreement will have to be respected, and the court must ordinarily not interfere with the constitutional amendment. The NJSC case is, I think, the typical example where these evils of the basic structure have come to light, and the judiciary itself decides that the interference of executive in its affairs is a violation of the basic structure, is struck down. There is a great deal of criticism on this particular judgment of the Supreme Court, and probably sometime in the future it may be reconsidered, you never know. But it has the good thing, the silver lining, is that it has brought to the fore the problems with the basic structure, or the problems with the interpretation of the basic structure subsequent to Kesavananda. The third problem with basic structure is that in theory, constituent power is absolute. There can be no restrictions on the constituent power whatsoever. So even if there is an express restriction which is laid down in the constitution itself, like it is in the German constitution, that also will not act as a restriction on the constituent power, because the constituent power by its very nature is absolute. So, and it is not that the constituent power is going to be exercised by a particular body, that is the parliament. People at large will always have the right to revolt. If there is any revolt, and if there is overthrowing of the government, and if the entire setup is overthrown, constituent power will exercise itself and make a new constitution. What is the court going to do in that case? So therefore, in theory, there can be absolutely no restriction on constituent power. So no matter what you do, no matter how the jurisprudence develops, that particular jurisprudence is never going to be full and final. These things are always going to change. Change is always the constant, especially when it comes to constitutional jurisprudence. So no matter how well you interpret the constitution, how many basic structures, no matter what expansive meaning you give to the basic structure, it is always subject to the people, because ultimately it is the people who are the real sovereign. And if the will of the people is to act in a particular manner, then that will of the people is obviously going to prevail. And when we see the exercise of judicial review by the Supreme Court, we will notice that whenever there is a coalition era, the judicial review becomes stronger. The Supreme Court appears to flex its muscles whenever there is a weaker government. And whenever there is a strong government which has a strong mandate, the judiciary will ordinarily hold its hands back. And this is an evidence based on empirical findings. If we are to see the judgments of the Supreme Court, we will notice that in the 90s, there is a great amount of judicial review expansive interpretations. We have cases such as S.R. Bommai and several other judgments. We have Vishakha. All of them have come in the 90s. And even in the UPA era, where there was not a strong full majority government in the center, we saw that judicial review was rampant. So therefore, ultimately, it is the will of the people that prevails. If, for example, there is a constitutional amendment, if to 368, which says that we will go to the people to amend the constitution, if the procedure laid down in 368 itself is amended to say that we will go to the people, we will take a vote, and after that vote is passed, if more than 50% or whatever percent feel that the constitution needs to be amended in a particular manner, then it will be so amended. If this amendment is challenged, then is there not going to be a conflict between elements of the basic structure itself? Because democracy ultimately is a part of the basic structure. Ultimately, it is the people who are sovereign. So therefore, if the people exercise their will in a particular manner, can the court really interfere? These questions may also crop up, and therefore these theoretical questions, which at present we feel that need not be considered or may be left to the domain of the academicians, may sometime in the future turn out to be a reality and be considered by the courts of law. So therefore, there is to end on this note that this theory of basic structure or any other theory which has been ever developed by the court is never going to be constant. It is always going to be questioned. It is always going to be debated. It is always going to be up for challenge. And these theories, these doctrines are always going to change. Change is always the constant, especially when it comes to constitutional law. And as academicians and as lawyers as well, we will have to develop this habit of critically analyzing everything. So we know that there is a basic structure, but we must not stop at that. The study of law is not something which is to be looked at from a positivist point of view. We are not Austin when we study the law. We have to look at it from an ought perspective, what the law ought to be, how the jurisprudence ought to develop, and it is in this manner that scholarly treatises will be produced, and scholarship in constitutional law, or for that matter any law, will be produced. At this note, I would like to end this short narration on the basic structure, and I think we can open it up for questions. Thank you.
Thank you so much, Sudhanva, for that illustrious discussion. And it was really nice of you to rather deal with the important nitty-gritties of all the judgments. We talked about Shankri Prasad, and then we eventually moved on to Kesavananda Bharati. So it was indeed a fruitful discussion, I would say. And then your feedbacks that you had provided in the end, that is something I think would be a takeaway for all the attendees of this particular session, wherein you argued that this basic structure also has to be curtailed to a certain point, because what eventually is happening is that basic structure is being read into each and everything that each and every amendment that is being challenged into the Supreme Court. So thank you for that feedback, and that's indeed one of the most enlightening thoughts that I think you have provoked in the minds of all our listeners today. And with this note, I would just want to open the floor for any questions. So if you guys would have any questions, you guys can just turn on your microphone, you can unmute yourself, and just feel free to ask any question.
Hello.
Yes, Akanksha, we can hear you.
Oh, hello, Karun.
Hi.
So this was a very great session to join, and very nicely summarized the whole journey of how we reached to the basic structure. So I wanted to ask from Sir that he mentioned that he doubts that parliamentary structure of government is a part of a basic structure or not. So I wanted to know more about his views on this comment particularly.
As to what is the element of the basic structure, what can be the elements of the basic structure, the court left it to the future benches to decide. And in one particular case, now I don't remember the name of the judgment, it was held that parliamentary form of government is a part of the basic structure of the constitution. But let us see what is the philosophy of the basic structure. The philosophy behind the basic structure is that if there is such an amendment which takes away the very character of the constitution, or if there is such an amendment after which the constitution will not remain the constitution as it was, or that some grave problem is going to arise with the constitution as it stands after the amendment, then the basic structure will have to come into play and restriction will have to be imposed on that particular amendment. Now, if we are to not have a parliamentary form of government, if the people are to decide that let us have a presidential form of government, it is not that democracy is going to be obliterated. It is not that rule of law is going to be obliterated. It is not that any other principle which forms part of the basic structure, take for example the supremacy of the constitution, any other feature. It is not that any of this is going to be affected by a presidential system of government. So therefore, I don't think that if there is some other form of government, a presidential form of government, so to say, the basic structure will be violated. Or for that matter, even let us say federalism. If we have a unitary form of government, as it is, I think that we have a stronger unitary form of government. It is less federal, it is more unitary. We have a stronger center. So if we are to have completely a unitary form of government, or contrary to this, if we are to increase the power of the states, if we are to amend the list 2 of the constitution and give more power to the states, it is going to impact federalism in some way or the other. But it is not going to impact the structure of the constitution. It is not going to impact the philosophy of the constitution. So according to me, when we interpret the basic structure of the constitution, it is the philosophy of the constitution which matters a lot. And moreover, ultimately, the constituent assembly thinking it right for itself to make a particular constitution, or to say that there should be a particular form of government, and another parliament exercising constituent power, saying in some other manner, opining in some other manner regarding the structure of government, I don't think it is going to affect the basic structure in a way. It is ultimately going to be the exercise of constituent power by the subsequent parliament. And such exercise of constituent power, if there is a room for reasonable disagreement, like I said, should be respected. And therefore, I don't think that if there is a presidential form of government, or if there is any other form of government, or if the principles of federalism are affected, it will violate the basic structure, because ultimately the philosophy of the constitution remains.
Indeed, sir. Thank you so much. I guess that answers my question. Thank you so much.
Thank you, Kanksha, for that question. And Sudhanva, that was a great answer. So, anyone else who would want to ask any questions, or has anything that he or she would want to discuss about? I think, Sudhanva, that judgment that you were particularly citing in that Sajjan Singh case, which William talked about Justice Mudolkar dissenting. So Justice Mudolkar then, cited a judgment of the Pakistan Supreme Court, which says that, at a certain point of time, you have to curtail the powers to amend the constitution. So that was a judgment, I think you were citing. So I just could recall, because that was a judgment of the Pakistan Supreme Court back then. So back then the Pakistan Supreme Court had probably developed this jurisprudence that not all that all parts of the constitution can be amended, and India was kind of still still debating upon this topic. That Mr. Palkiwala, one of India's best, trying to convince the court that please accede to my request that the state cannot do this. So on that note, I think if anyone would have a question, can please ask. I think we have a question from Vartika. So Vartika asks you. No, Vartika. No, that's not a question.
I would like to add something on this Pakistan Supreme Court aspect.
Yeah.
As far as my knowledge goes, there is no precedent similar to the basic structure. Pakistan Supreme Court has not devised something similar to the basic structure, imposed some implied limitations on the power of constitutional amendment. I may be mistaken, correct me if I am wrong, but that is not, I don't think that is the position. And moreover, I don't think when we discuss constitutional jurisprudence, Pakistan even matters, because the development of the principles of constitutionalism, rule of law, all these principles don't exist in Pakistan at all. So from a comparative constitutional law point of view also, I don't think Pakistan deserves to even come into the picture.
Actually, Sudhanva, while actually dissenting in that Sajjan Singh case, Justice Mudolkar had actually cited this particular judgment of the Pakistani
Yes, I am
Supreme
aware.
Court. Yeah,
I am
yeah.
aware, but I don't think that judgment dealt with basic structure, something similar to what was held in Kesavananda. I'm not
That's right.
sure
That's
about
right.
it.
That's right. That's right. That's right. That didn't talk about a basic structure, but it talked about something similar on the grounds that till what extent are we going to allow this power of Parliament to amend the to amend the constitution, till what extent can it be allowed. So that was a judgment which was basically relied upon by Justice Mudulkar back then to dissent when we read his dissenting opinion. So that was a judgment that Justice Mudulkar relied on. And
There is an interesting article on life law
uh,
pertaining to the dissent of Justice Mudolkar in
okay,
Sajjan Singh, and
okay,
that article discusses all this in detail.
okay.
How Dita Conrad, it
Mhm.
also in fact discusses about Dita Conrad, how his
Mhm.
article played a role, and
Mhm.
how his
Mhm.
lecture in Banaras Hindu University was
Mhm.
uh,
Mhm.
it played a pivotal role in Keshavananda,
Mhm.
since
Mhm.
there was absolutely no precedent available.
Mhm.
So there is
Okay.
a very interesting article on live law.
Okay. Maybe we all will read after this session. And we have one more question from Vartika. So Vartika asks that how does the Constitution, through basic structure, talk about separation of power in basic structure? So I hope that that is, if I'm framing it right. So Vartika writes that how does Constitution, through basic structure, talk about separation of power in basic structure?
No, I did not get that question.
Let me just read it once again. So what she writes
No,
is that how the
I heard you right, but
uh-huh.
I don't understand what the question.
Yeah, because even I'm trying to get it what she exactly means. So let me just frame it for you. She says that how does the Constitution, through the basic structure principle, talks about the separation of power. So okay, fine. So basically, she means that how do you talk about separation of power and basic structure? Like what is the relation between the two?
See, separation of powers is always, in fact, even in Keshavananda,
Hmm.
one of the judges I think have held that separation of powers is a part of the basic structure, because if there is no separation of powers, if one particular institution trumps the other, then this argument which Palkiwala had made in Keshavananda, that a particular institution, legislature or judiciary, whatever, legislature becoming the master of the constitution would arise. So therefore, this separation of powers principle will always have to be respected. And this jurisprudence was developed further in the S.R. Bommai case,
Right.
pertaining to separation of powers forming part of the basic structure of the constitution. Of course, federalism was one important aspect, but also separation of powers. And then later in the NJAC case also, there is some discussion on separation of powers being part of the basic structure. And the judges' cases, Supreme Court Advocates on Record versus Union of India, I think 1992, which brought in the collegium system. So all these cases have discussed about the principle of separation of powers being part of the basic structure. And there is good reason for saying that separation of powers is a part of the basic structure. Because if there is no separation of powers, the principle of judicial review is also going to be impacted. If the principle of judicial review is going to be impacted, then the fundamental rights are also going to be impacted. And therefore, it is going to lead to a situation where one particular institution trumps the other. And then all other principles can be obliterated to some extent. So therefore, much like democracy, separation of powers is also part of the basic structure, should be a part of the basic structure. It is rightly so held by the Supreme Court. But at the same time, what are the contours of this separation of powers? That also needs to be considered. It cannot be interpreted in such a manner that in the NJAC case, you think that there is an interference with the independence of judiciary. There is also an interference with the separation of powers, and therefore out goes the amendment. It ultimately has to be something which is extreme, because the genesis of Keshavananda, the core of the argument in Keshavananda was regarding extreme amendments. So unless there is an extreme amendment, no element of basic structure can be brought into play.
Right. Right. So is there any other question that we can have for Sudhanva? As lawyers, if we keep quiet, that is that is a evidence towards the fact that we are not good lawyers. So anyone would want to speak?
Sometimes keeping quiet is also a quality, because lawyers have to be good listeners.
That's right.
Sometimes
That's right. That's right.
simply listening and not questioning is also
So in the meanwhile, while you guys might think of a question, because I think it's already 6 and we were to wrap our 6 p.m. already, and we are just to wrap our discussion for today. So I remember, I read it that while Mr. Palkiwala was arguing this matter before the Supreme Court, so he was standing against Mr. Sirvai back then. So I'm sure that you all must be knowing about Sirvai being being constitutional law students. I'm sure that you guys would have heard about Mr. H.M. Sirvai. So while Sirvai was arguing this particular matter, Palkiwala just rises up and he reads a particular. There's a piece of paper he had, and he just reads out few observations that were made in that particular article. And after he completes his submissions, so he made this one more submission before the honorable court, and what he said was that, my lord, the observations that I made in this particular matter, which I argued before this bench, has been made by my learned friend, that was Mr. Sirvai. So that was one big embarrassing moment, which Palkiwala created back then for Sirvai, while while this matter was actually being argued. So so just I'm just so fascinated by the way Palkiwala took the entire discussion, and how, as a lawyer, he had just helped the Constitution of India grow, and as a matter of fact, has indeed kind of was a pivotal had played a very pivotal role in ensuring that our fundamental rights is something which is not taken away from us. So that's why we have all reasons to remember Mr. the great Nani Palgiwala. So yeah, do we have any questions? I mean, I said this because you guys can get time to think.
Hi Karan, Akanksha here again.
Hi.
So I wanted to ask from Sudhanva sir that, sir, you mentioned that we have always observed, and there have been empirical researches about this, that when there is a weak government, Supreme Court takes very audacious decisions, and then came the NJAC. So do you believe that in the current scenario, if NJAC judgment is challenged, what will be the stance of the Supreme Court according to you?
All that I don't think can be predicted. The interesting fact is that NJAC was decided in 2015 when we indeed had a government with full majority at the center. So it is not that some constitutional amendment will not be called into question, or the court will be completely reluctant in all cases. But this is regarding the general tendency which is seen. The general tendency of the courts when there is a strong government is that the courts usually will not interfere. And that is really evident right from the time of Pandit Nehru and Indira Gandhi up to the current in the current framework. So therefore, but then nevertheless, the courts have even interfered when there have been strong governments. It is not that courts will not interfere at all. The whole point being that generally the tendency is that the courts to lay its hands off if there is a strong government at the center. But now this independence of judiciary aspect, if there was to be the NJAC, then the judiciary would have lost its monopoly in appointing judges. So therefore, probably that was a factor which played on the minds of the judges, and therefore NJAC was decided in a particular manner. So we can't really be sure as to when NJAC will be reconsidered, whether at all it will be reconsidered. But I think there are good grounds to reconsider the NJAC case. It cannot really be predicted as to when and how, because an occasion has to arise, and for an occasion to arise, another constitution bench in some particular judgment deciding the constitutional validity of some constitutional amendment will have to think that a particular observation in NJAC case is probably not correct or requires reconsideration, or that if there is a further constitutional amendment pertaining to this NJAC issue, if there is some other commission or committee which is established for the appointment of judges by a constitutional amendment, then it will again obviously be challenged, and then all these questions may be freshly considered. But at present, according to me, there is only the 103rd constitutional amendment pertaining to the reservations over and above the existing reservations to the economically weaker sections, which is up for grabs in the Supreme Court. Apart from that, I don't think there is any other constitutional amendment which is challenged presently in the Supreme Court. And unless there is a constitutional amendment which is challenged, I don't think this question can be will be reopened.
Thank you so much, sir. I hope if it's ever reopened, we are here to discuss it again with you. Thank you, sir.
Thank you.
And I'll make sure that I get Sudhanva back for this discussion sometime later. And
Yeah, definitely, Karan. Thank you.
yeah, and with on this note, let us end this conversation, because we have already crossed 5 minutes of our promised time slot. It's already 6:05. So Sudhanva, we thank you for just being with us and agreeing to speak on this topic at such a short notice. We are indeed very grateful to you. And as I said, it was a great discussion, and your inputs in the end, wherein you said that basic structure has been propounded by the courts, and courts are still kind of developing and redeveloping upon the concept of basic structure, and applying it in kind of wildest form of imaginations that we can even think of. There needs to be a curtailment on this philosophy of basic structure as well somewhere. So thank you for that input. That input is something I think it's very thought provoking for all of us who have attended this particular session. And I'll just leave the floor open for your concluding remarks, Sudhanva, if you have to make any, and we'll just close the meeting after that.
Thank you very much, Karan, for inviting me, having me here. It was indeed a proud privilege to be amongst all of you and discuss a topic which is very dear to me. And the strange happenstance that today itself, Shri Kesavananda Bharati passed away, and we are discussing the case of Kesavananda Bharati, which becomes all the more relevant today. So therefore, it was really a very good. I had a very good time discussing Kesavananda. It is this particular element of our jurisprudence is something which is very dear to my heart, and I think that there is much more development in this regard, which can happen, and there are some things which also need to change. And obviously, jurisprudence is something like waves of the sea. It keeps coming and going. There is one particular wave of liberal constitutionalism today. Probably tomorrow we will see a development of a jurisprudence on populist constitutional law. Similarly, there is a development of the pro-judicial review jurisprudence in the present times, particularly in the last 3-4 years, where we have seen development of several doctrines on transformative constitutionalism, constitutional morality, and so on and so forth. It gives a great opportunity for academicians and lawyers alike to discuss and deliberate upon all these issues, particularly from the comparative constitutional law angle, looking at how the developments have taken place in the foreign jurisprudence, and enlighten ourselves, keep ourselves updated, and think out of the box on all these issues, and continuously deliberate them and discuss them. And that is how the jurisprudence keeps on developing. So one more thing that I forgot to mention back in my talk regarding use of basic structure to challenge legislations also. Basic structure was never intended to be used for challenging laws. Now we see very often that loose statements are made that a particular law violates the basic structure of the constitution. It violates secularism. It violates so and so element of the basic structure. But this basic structure was never intended to be used for challenging plenary legislations. So what we get to learn from this, the learning from this is that jurisprudence develops in a very radical manner sometimes. And in India, at least, we have seen that our jurisprudence is developed in a very radical manner. It has developed very quickly. It does not happen like this in any other country. So therefore, at the same time, it also gives a very greater degree of responsibility on the academicians and the lawyers, because we have to deliberate and discuss, and there is ample amount of material available with us to deliberate and discuss, to write, to read. So this habit of deliberations and discussions on constitutional jurisprudence will have to be inculcated, and it is going to take us very far. Thank you.
Thank you, Sudhanva. Now, for all those young law students that we have present in this meeting, so eventually, with this idea of Rotary and Rotaract coming in, we are coming up with an idea wherein we would want to connect globally all the Rotaractors, and for that matter, all the people associated with Rotary who are professionals in law. So we have an idea which is in the pipeline, which we have called it as REALSA. Now, REALSA stands for Rotaract International Law Students Association. So we are working on that idea and time frame. So just in case anybody would want to know more about it, you can just drop in a text message, or maybe just can drop in an inquiry on rotaractclub.noidayouth@gmail.com. Or I'm sure you guys would have received the emails, so you can just take that email from there and just respond to that email. If you just want to know more about this particular initiative that we are going to take up. So this initiative would basically be connecting lawyers and professionals from all across the globe. We have people coming in from Oxford, Cambridge, and all those people whom we can think of. So that is the idea behind this. Anybody would want to be a part can definitely join in. And also, so as soon as the session gets over, we will be having another session that happens on Instagram Live. Now that is kind of stress buster for all of you. So those of you who follow our Instagram channel can it's our Instagram ID is rotaractclub.noidayouth. So can just come online and just watch a discussion which is going to happen. There's another discussion which will be happening on our Instagram channel. So just in case if you guys would want to join, please feel free to join. And thank you for joining, everyone. And I'll make sure we get Sudhanva back sometime very soon, and we have another round of discussion with him. And Sudhanva, thank you so much for your time, and thank you so much for your efforts. Thank you, man.
Thank you. Thank you, Karan.
Okay, guys. Bye.